Okay, so in chapter 26, we're talking about antitrust law. And primarily in this chapter, we're focused on the Sherman Antitrust Act and the Clayton Act, which kind of fit together to um, really foster the goal of consumer protection. The idea is that competitive nature in business is good because one, it drives down prices, and two, it fosters innovation. All right. Um, so let's get it going. So the Sherman Antitrust Act is so named the antitrust piece. It used to be that um, trust exists that would buy stock and usually controlling shares of um, every market player in a particular industry. And the main motivational reason for um, the Sherman Antitrust Act was the Standard Oil Trust, which essentially purchased controlling shares of virtually any oil production company. And they were so effective and so pervasive that they pretty much owned all oil production and sales in the United States. So um, the net result was high prices for consumers and um, poor service, essentially, right? Because when there's a monopoly, customer satisfaction and service really isn't that important because where else are you going to go? What else are you going to do, right? Um, and so in comes the Sherman Antitrust Act, all right? And it has two sections. The first section basically pursues contractual agreements in restraint of trade. And I have the two to tango. Yeah, here we go. The reason for that is um, both contractual parties are obligated, are liable if a Section 1 violation is found to exist under the Antitrust Act. And we'll talk about what falls under Section 1. And then 2, attempts to monopolize or conspire with any other person to create a monopoly. So this one's a bit more broad, Section 2 is, because it allows for one person, or not one person, one entity. It could be a person, but typically it's an entity, a corporation, to be held liable for attempts to monopolize any particular industry or business. All right. Let's define monopoly. So a market in which a single seller controls the market. If you want a widget, Widget Co. is the only manufacturer and seller of widgets. All right, um, that's a monopoly. Um, you don't have to be a single. It doesn't have to be a single seller situation to be deemed a monopoly. The correct term, although not in your text, is oligopoly when there are a relatively small number of sellers. But the result can be the same. For instance, if there are two main manufacturers or two main suppliers of anything, of any commodity, right? Um, then they really don't have, and let's just say it's automobiles. You can buy automobiles from General Motors, you can buy automobiles from Ford. Obviously, there are other manufacturers, but let's say in our hypothetical. So that's an oligopoly. And neither one of them has to compete very hard on price because one can be a bit cheaper than the next, and that's fine. But neither supplier to the market could manufacture enough to supply the entire market. So either way, there's going to be market share. So there's not much need to try to compete based on prices, or really to innovate. All right, and that's an example of an oligopoly, and that can result in actions under the Sherman Antitrust Act or Clayton Act, as we'll get to later. I will start with the same caveat that I started with Chapter 24. since we're dealing with federal law, the interstate commerce is effective here. So um, the Interstate Commerce Clause, which means that in order to be regulated, the conduct must affect commerce between the states, right? And of course, the opposite of commerce, the opposite of interstate commerce is intrastate commerce, but that really is becoming more and more of a fiction. It is exceedingly difficult to have a business where, soup to nuts, the entire supply chain and staffing and financing and operations all comes from it within one state. That is very difficult to do. So in reality, we're talking about virtually all business. All right. Um, have a graphical visual that details where we're going in the next portion of this slideshow, details the difference between Section 1. So Section 1, just keep in mind, 1 is 2, in that there are always going to be 2 people liable under Section 1, right? Any agreement between 2 or more parties that unreasonably restrains competition and affects interstate commerce, all right? And Section 2. Um, Honestly, you can violate Section 2 um, by doing by being too good at what you do. And we'll talk a little bit about that in the rule of reason. But Section 2, the possession of monopoly power in the relevant market. And so monopoly power is the ability to control the market and operate as a monopoly. And the willful acquisition or maintenance of that power as distinguished from its growth or development as a consequence of a superior product, business acumen, or historical accident. So really what we're saying here is that um, it's acknowledging that effective businesses, particularly with a competitive advantage or intellectual property that the competition doesn't have access to, can grow into a monopoly, right? And that's distinct from other types of anti-competitive behaviors. Okay.